Good morning, Professor. I don't know whether to say Kruger because sometimes I understand Kruger is pronounced as Gruyere or something. I'm not sure. Is it Kruger? Good afternoon to you.
Thank you, Chief Justice. Good afternoon.
Yes. Thank you very much for availing yourself for consideration for appointment as a judge of the Eastern Cape Division. I will ask you some basic questions, and after that, I will allow the JP to ask you whatever questions he has, and then the Premier, and then commissioners after that also will get a chance to ask you questions.
Thank you.
Now, Professor Krüger, I see here on your questionnaire that you have a string of qualifications. What degrees have you got?
I have a BA degree and an honours degree in political science, and then thereafter I completed an LLB degree. I did a certificate in labour law. I did a ABET qualification in isiXhosa. I did a PGDHE, postgraduate diploma in higher education, and a Doctor of Philosophy in law.
Yes. And you got your PhD in 2009, is that right?
That is correct.
Yes, and your first degree BA you got in 1996.
Correct.
And your honors in 1997. And then the postgraduate diploma, is it in higher education?
Yes.
Yes, and then you got your PhD. You got your LLB there as well.
Yes.
And you started working at the Center for Community Law and Development in Potchefstroom.
Yes.
Yes, how long did you work there?
I completed my articles, and thereafter I moved back to the Eastern Cape to join Rhodes University as an academic.
After your articles, did you get yourself admitted as an attorney?
I was admitted as an attorney in 2001.
Yes. In terms of actual practicing?
As an attorney, I haven't practiced. For about a period of 3 months, I worked as a professional assistant on a part-time basis. But by that time, I was trying to find my feet in the academy, and I decided to focus on one thing at the time. So I have completed my articles. I was admitted. And then subsequent to that, I have, when I joined Rhodes University, I've presided in student disciplinary matters, and I've also, in 2013, started working as a commissioner of the CCMA. So those are, and that's the extent of my practical experience in addition to acting as a judge.
Yes. So how long did you, for how long were you a commissioner at the CCMA?
I was appointed in 2011, and then there was some administrative glitch, and I only completed the training course in 2012, and I started hearing cases in 2013. And I'm still under contract with the commission.
Yes. Were you part-time or full-time?
Part-time.
Part-time. And being part-time, were you doing both mediations, mediations and arbitrations?
Both of those, on a limited basis, given my full-time employment at the university.
Yes. What were you doing more? Is it mediations or arbitrations, or you can't tell?
One would say, a matter would start out as a conciliation / arbitration, and then in those instances where the conciliation fails, you would immediately proceed to an arbitration. I would imagine that the bulk of the matters would settle at conciliation, but I most certainly have a number of matters that I've presented awards or written awards in mediations.
Are you able to say on average how many matters you think you would arbitrate in a year?
Chief Justice, that would be really very difficult for me to give a number on it. I would say not very many.
Yes.
From 2014 until 2020, I was the Dean of the Faculty of Law, and during that time in particular, I had very limited involvement with the CCMA, given my responsibility to the university community. So while I held the position, I would be lying if I tell you that it was 20. I don't think, definitely not 20. I would say more in the region of 5 or 6, if that.
Is that in a year?
Yes, in a year, if that.
Yes.
But as I pointed out, I also dealt with student discipline, which is a quasi-judicial discipline, a quasi-judicial body within the university, and that I continue to do.
Yes. When you have done arbitrations, has there been legal representation for the parties, generally speaking, or not? I know that the CCMA, I think most of the time there is no legal representation in arbitrations and mediations, but I think there are circumstances where there is legal representation.
Yes.
But what normally happens when you do arbitrations in terms of legal representation?
Very often it would be a trade union representative on behalf of the employee, and then someone from HR on behalf of the employer. But as I've said, I haven't in recent years done many of those. I can decidedly remember that I had a matter involving constructive dismissal in which there was legal representation on both sides. But I cannot tell you when that was. It was a couple of years ago.
So if you look at the number of arbitrations you have done at the CCMA, and I'm focusing on arbitrations because I think that's the only thing that I can think of that comes close to what you do as a trial judge, as a judge. Are you able to say, well, over the years I've done maybe it's about 20 arbitrations over all these years at the CCMA, or maybe 10, or maybe 50? Are you able to give us an estimate, just to give us a picture of how much exposure you have had to something that comes close to a trial?
I would say roughly 10 to 15.
Roughly about 15?
Yeah. I could count them, but I unfortunately don't have that information at my fingertips at the moment.
Yes. And of those, were there some that had lawyers involved representing the parties?
Yes.
Yeah, there were those that had lawyers. Only a few, or a substantial number of the 15 or so?
I would say in the majority of instances, not.
Yes.
It would be an experienced trade union representative and a HR practitioner.
Yes. In the arbitrations in which you have been involved, have there been issues of the admissibility of evidence that you have had to deal with or not?
Yes.
There have been such issues?
I'm saying admissibility of evidence, but I'm actually thinking particularly more of student discipline, because in student disciplinary matters, that was very often an issue.
I'm sorry, can you pull the mic closer to you?
Sorry, just hang on. It would possibly be something like hearsay, I would imagine, but since I don't have that information at my fingertips, I would imagine yes, but I can decidedly remember student disciplinary matters more that had evidentiary issues that had to be decided on the basis of inferential
Yes.
reasoning rather than concrete evidence of someone seeing the student engaging in the particular behavior. So
Yes.
in those instances, most certainly, the decisions provided would have set those, would have dealt with the admissibility of evidence and
Yes.
the chain of.
How long have you acted as a judge?
I have a total of 25 weeks that I was appointed, and then I had 2 criminal matters that both took me beyond term time. And so I would say 25 weeks of term time that I was appointed, and then beyond that, 2 or 3 weeks of finalizing my criminal matters.
Yes. And in terms of arbitrations that you have done, have you been taken on review? And if so, are you able to share with the commissioners what the outcome was of such reviews?
Not that I'm aware of.
Not that you are aware of. And in terms of decisions or judgments you have given as an acting judge, have some been taken on appeal?
I have granted leave to appeal in a number of matters, but insofar as my knowledge goes, that those appeals have not been heard.
Yes.
I have, let me just make sure here, I've got the statistics here. I've got 5 applications for leave to appeal, of which I granted 4.
Yes. And you have done motion court, you have done trial matters as well.
Yes, yes, I did.
Yes. And in terms of full bench appeals, have you participated in full bench appeals?
I was set down, I have definitely participated in full bench appeals in the first or the second week of the 4th term. I was set down for appeals in Mthatha with Acting Judge Bielefeld and Judge Tokota. And from that week, most certainly, we've participated and heard 2 matters that went on appeal, full bench appeal.
Yes. When you sit on appeals, dealing with a judgment coming from the magistrate's court or coming from a single judge when you are sitting on full bench appeals, and you are dealing with a decision made by the magistrate or judge in exercising a discretion, what do you look for in order to see whether you may change that decision or not?
Insofar as a criminal matter is concerned, it depends on whether it involves the sentence or the conviction. And if it is in relation to the sentence, it would be if it is startling or inappropriate that the appeal court may substitute the decision of the trial court. And insofar as the guilt of the accused is concerned, it would be that one would have to dispassionately look at the reasons provided by the applicant for leave to appeal and consider whether there is a prospect of success, which is not far-fetched, but that is based on the facts. And in those instances, one would then interfere and change to reflect the correct position insofar as the finding is concerned.
If it's a civil matter or a motion matter, the decision that you are supposed to, that you are considering whether to uphold or set aside was a decision made in the exercise of a discretion.
Yes.
What would you look for in deciding?
Apologies. One would consider the standard that is set out in the Supreme Court Act, which one would then consider whether there are reasonable prospects of success, and if those prospects are not the prospects, if the findings are based in fact that are inappropriate, the exercise of discretion by the judge was incorrect, then in those instances, based on the evidence that was presented and the legal principles applicable, one may interfere in those instances.
Just repeat, I want to make sure I don't misunderstand you. Under what circumstances would you interfere?
With a decision, say, for example, by a judge in a matter, a civil matter, or
Yeah, a civil matter, but the decision that is on appeal was the result of an exercise of a discretion.
one would consider the evidence and whether the evidence supports the exercise of the discretion, and whether the law, the exercise of the discretion is within the bounds of the law. Because the exercise of discretion is not unfettered, and one would consider that within the context of the facts of the particular case.
If you are dealing with factual findings made
Yes.
by a trial court and you are sitting on appeal, are you familiar with the approach that a judge sitting on appeal is supposed to follow?
It would be, unless the finding of fact is so startlingly inappropriate, one would not lightly interfere with the findings of a judge made in a trial court.
Yes. What can you share with the commissioners in terms of the experience you have had in motion court?
I have had the opportunity to deal with quite a number of opposed motions, 22 opposed motions, and that was ranging from a wide variety of matters, from the purely procedural to matters of substance. And then in relation to the unopposed matters, I have had duty for about 4 weeks.
Yes. Well, I guess that after the October interviews, every candidate who comes here for consideration for appointment as a judge for the first time would make sure they know the plus con evens rule.
Yes.
You know that rule.
Yes, I do.
Yes.
Yes.
I'm going to hand over to the Judge President who will ask you questions. Okay. Judge President.
Good morning, Professor Kruger.
Good morning, JP.
What is the test in civil cases? Maybe to be fair to you, in criminal cases, proof must be beyond a reasonable
Yes.
doubt. What is the test in civil cases?
On a balance of probabilities.
Concern has been expressed that you lack practical exposure. Would you say that comment is fair, or how would you deal with that comment?
JP, I think obviously that I'm very aware of the fact that my candidature is not one that follows the normal route, in the sense that I've been a practitioner for an extensive period of time. However, I would say that it's not a question of having no practical experience, as I have some practical experience. And then very pertinently, I think post-1994, there was a deliberate move when this body was established to broaden the pool of potential candidates for judicial appointment, and in acknowledgement of the rich, relevant experience that come from different areas. And I think in particular from the academy, what I found quite useful is I've never had concern post articles to consider the law in a partisan fashion. I've never had to shape a case for a client. I've always considered the law dispassionately and considered both sides in the application thereof. So I would say that my extensive research and analytical skills empower me to deal with also issues of practice.
Yes. Let's get rid of this notion about plus-con events. What do you know about that?
Thank you. If there's a dispute of facts that applicant in motion proceedings ought to have foreseen, the matter is decided, or when a dispute of facts arises, then the matter is decided on the basis of the common cause facts, in other words, the facts of the applicant which have been acknowledged, admitted by the respondent, and the facts of the respondent.
Yeah.
So it's basically a warning rule to an applicant to make sure that motion proceedings are appropriate and there's no dispute of fact.
Thank you. One of the judgments referred to by the GCB
Yes.
in their commentary relates to civil contempt of court proceedings.
Yes.
In that context, what is the test for establishing the guilt of the respondent in civil contempt proceedings?
There must be a court order which has been willfully and deliberately
Sorry,
disobeyed.
I'm asking you the test.
The test.
Yes, remember, it's either on a balance
On
of
a bala-
it's either on a
Yes,
balance of
okay.
probability or beyond reasonable doubt. What is the test?
Yes, there has been a number of cases, and in the course of the judgment, I traversed those cases. So there was Farki, then there was, and Farki was distinct, or there was the majority and the minority judgment, and then there was the CC judgment of Judge Nkabinde, and I'm going to get the name wrong. I think the second judgment in any case was Machabeng. And in Machabeng, Judge Nkabinde endorsed the distinction between civil contempt, where you have to establish on a balance of probabilities, where the only thing that you want to get is compliance with a court order, and where you have to establish non-compliance on beyond a reasonable doubt, where you want to ensure that there's the further possible criminal consequence that may follow from that. And that was endorsed by the majority of the Constitutional Court in Machabeng.
Yes. From the list of judgments that you finished the commission with, I see you penned 22 opposed application judgments.
Yes.
And 2 criminal trials were run by you. You penned judgments there.
Yes.
You ran 3 civil trials, 2 criminal appeals, 5 applications for leave to appeal, as you have alluded to. And then on another occasion, you must have issued an order with reasons to follow, which you did once in a while. So my last question is this. Which of the judgments that you penned do you believe demonstrates your knowledge of commercial law?
Of commercial law.
Yes.
If you give me a second here. I think Gqeberha versus City of Cape Town.
City of Cape Town.
Yeah, it's a matter involving a procurement, but it's a matter that essentially is about money.
At which page is it?
On my list, it's on page 3.
Yes. All right. Is that the only judgment you can refer to?
No, if you give me a... There's Headbush versus Office Automation on the first page, which is also about a contract.
Yes.
And Express Petroleum is the one about the commercial, but that's about contempt of court.
Yes.
I would say Nalitemba was an application for summary judgment. That's on the top of page 2, which also involved significant dispute of fact between the parties.
All right. If you can indulge me, Chief Justice, just one last question.
Yes, okay.
In fact, it's just one point that I want to make. The DJP at Gqeberha has commented that you were able to cope with the workload presented by a busy motion court and presided over a long-running criminal trial that presented itself with the challenges associated with a child rape matter.
Yes,
Will you confirm that?
that is correct.
Thank you, CJ.
Thank you, JP. Premier,
Thank you very much, CJ, for the opportunity, and greetings once again to all members of the JSC. I suspect JP has largely covered me on a number of questions he has asked. I just have one question that I'm interested on. Prof, good morning also.
Good morning, Premier.
Do you find the move from academia to the bench interesting or challenging? Why are you?
I find it interesting and challenging. I don't think that a challenge is something to be running away from. I really enjoyed the opportunity that was given to me as a result of broadening the pool of possible candidates. I enjoyed the opportunity. I found it interesting. I found it rewarding. And I found it to be a lot of work. And I'm always up for a challenge. I relished it.
Thank you, Sujay. I'm fine.
Thank you, Premier. I now will allow commissioners who wish to put questions. Professor Krüger,
Yes.
The commissioners will put questions to you, and they will do so largely to try and see how your appointment would meet the selection criteria that have been approved by this body, and they include whether or not you are a person of integrity and whether or not you have the necessary energy and motivation, and whether you are competent, technically competent, and whether you have a capacity to give expression to the values of the Constitution, and whether you are an experienced person, technically experienced, and experienced in regard to the values and needs of the community. They will also look at, or they include, the question whether you have appropriate potential and what message your appointment would send to the community. Of course, the question of the diversity of the court, and the question whether you are a fit and proper person, whether you are duly qualified. They'll ask you questions aimed at satisfying themselves how your appointment would meet those criteria.
Thank you, Judge.
Thank you. I'm sorry, Judge President Lehodi helps me sometimes with the list, but I couldn't read his handwriting. But now he tells me what I see is supposed to be speaker. So, but now that he has said it, I can see. Commissioner Mapisa-Nqakula.
Thank you very much, CJ. Good morning, Prof.
Good morning.
How are you?
Fine. You?
Good. Prof, you've just said you've acted for a total of 25 weeks,
Yes.
all in all. And not only that, before then, you practiced as an attorney from July 2001 to the 30th of September. Whilst appreciating your academic achievements, and I'm sure all of us do, I would like to, what do you think you will be able, what impact do you think you'll be able to make in a court as now a full-time, permanently appointed judge?
Thank you.
Yes.
I think to some extent I want to hook this on what I've said earlier, and this has been my philosophy in terms of teaching students as well, is what students are facing and what I think practitioners are facing and what judges are facing is to solve legal problems. And I'm of the view that my research skills, my analytical skills, my commitment to the Constitution enables me to, whatever I don't know, and I'm not sure that there's anyone who knows all of the law and understands all of the principles. I am able to I understand the method of coming to the correct answer. And I believe that through the constitutional perspective that I bring, and with my relevant experience in legal research and engaging with the law, that I will bring a person to the bench who is not someone who has walked the traditional route, because it's not my understanding that a judge's position is as that of an ultimate practitioner. The role of the judge is not that of an ultimate practitioner, but rather someone who dispassionately has to analyze the facts and the law and come to a conclusion with the aid of practitioners to a just result within the framework of the applicable law.
If I may, I'll follow CJ.
Thank you.
Thank you very much, CJ.
Thank you.
I understand and I accept that. The issue on my side is, whereas you meet the basic criteria for appointment,
Yes.
but you definitely lack the necessary experience of practicing as an attorney, but also of being a judge. And I'm asking now because we are now considering your appointment to a high court.
I hear you. I take it from your question, Commissioner, that the 25 weeks that you regard that to be insufficient as demonstrating my ability to perform the work. I think, to the best of my knowledge, I have performed the duties of a judge in accordance with the law and the Constitution. And as I said, my understanding is not that practical experience is the only or the largely relevant criterion. It's a whole host of other things that go into it, unless my understanding is incorrect.
Well, I'm sorry, CJ, but it's just my last follow-up. Prof, are you certain that you do not need to be given more time to act in order for you to gain the necessary expertise which are required for you to lead a collective in a high court as a judge? And that will be my last question. Thank you.
I do not think that I mean, obviously, acting more would add to my experience, but I do not think that my candidature is without merit on the basis of the fact that I've only acted for two-thirds of a term, if that is the question.
I will go to the next commissioner, but just want to say this, which flows from Commissioner Mapisa-Nqakula's question. You accept, do you not, that if you talk about 25 weeks of doing trials and say that's what you are talking about, that amounts to, is it something like 7 months?
It's half a year, more or less.
It's about half a year.
Yeah.
I guess that you would say that if an attorney or advocate practiced for about that, or maybe a year, did that in a year, they should be ready to present themselves and be considered. Would you say that? Or would you say they would need more time?
Chief Justice, my understanding is then that, the other relevant experience that I have
Yeah,
is-
nobody says that there can't be other
Absolutely.
things, but when you are a judge in the
Yes.
High Court,
Yes.
your core function is to judge, and your
Mm-hmm.
core function involves trials, motion court to a very large extent. So, and you would be presiding in trials where there are experienced attorneys and advocates who are appearing before you, and you need to handle all the challenges that arise with that. You believe that the period that you have had of trials is sufficient to equip you?
I believe so.
Okay, all right. Commissioner Makwanishe?
Thank you very much, CJ. Good afternoon, Prof.
Good afternoon.
There is something that I would like you to clarify. The General Counsel of the Bar says that they are not happy with how you conduct, some practitioners are not happy with how you conduct trials. You seem to be, you stray from the facts presented, in fact, from the evidence presented, and you're easily distracted by irrelevant issues. What is your comment?
It is impossible for me to comment without a practical or concrete example. I am not able to respond to that. I can simply say that I can't think from the top of my head. If there was an example given, I would have been able to respond, but I cannot respond in the abstract.
Okay, thank you. And then the last one, CJ. Do you have any outstanding judgments, and how long are they?
I do not have any outstanding judgments as to date.
Thank you very much.
Thank you, Commissioner. Commissioner Gqeberha?
Thank you very much, just Jay. Good afternoon, Prof.
Good afternoon.
Thanks. I just want to, in passing, CJ, I see that in the CV, she doesn't indicate her state of health.
Oh, yes.
That is considered disclosable. And is there a reason why you decided you would not comment on this item?
I apologize, I didn't hear what you said earlier.
No, on page, I'm looking at your application form.
Yes.
On page 4, is item number 11. It's asking you if there is anything about the state of your health which should be disclosed before the commission, and you decided not to comment. Is there any reason why you...
That is an oversight.
That was an oversight.
That is an
Okay.
oversight. I
All
apologize.
right. Having cleared that, Prof, during the period you were acting on the bench, have you presided over matters that implicate socio-economic rights?
No, I haven't.
You haven't?
No.
Okay. I mean, tapping into your experience as a professor, do you think we have succeeded in having more of these matters coming before the courts as part of expanding justice to our people? If not, what do you think is the reason why we're not getting so many of these matters that implicate socio-economic rights coming before our courts? Thanks.
I think to some extent it may be a question of awareness on the part of litigants or potential litigants, and also access to justice, to have legal representation. Because socio-economic rights cases are typically brought by institutions like the Legal Resources Centre or CALS or one of these institutes, and they have limited capacity. I do think where there has been litigation. For example, in the Eastern Cape, there's been a lot of litigation on basic education, and that has made a positive difference in the lives of learners in the province. But I do think, obviously, what one should do is, within all the arms of government, there should be a explicit effort to comply with the legislative and constitutional standard, and to ensure that the socio-economic goods, whether that is access to social security or whether that is a question of education, basic education, that those are delivered to the people entitled to them.
Thank you, CJ. Thank you, Judge. Prof.
Thank you, Commissioner. Justice Betzer.
Thank you, Chief Justice. Good afternoon, Professor Kruger.
Good afternoon, Judge.
What you said earlier on reminded me about my old days at the University of Fort Hare. One of the professors there used to say that as a lawyer, you must either know the law or know where to find it. Mm-hmm. I've got two double-barrel questions for you. The first one, you appear to adopt a somewhat liberal approach in granting leave to appeal. You said you had 5 applications. In 4 of them, you granted leave to appeal. Mm-hmm. Would you care to enlighten this commission as to what the test is for grant of leave to appeal?
All right. It is whether another court reasonably could come to a different conclusion. Section 17 of the Superior Courts Act seems to up the ante quite a bit in respect of what a party should put before the court. And in particularly the matter that the JP referred to, the express ropax, there was a reference to a judgment of Judge Smith in the Eastern Cape High Court, where he made a very useful comment, in my view, on considerations for leave to appeal, in which he says it is indeed so that the addition of the word in the section seems to up the ante dramatically. However, it cannot be that one almost has to go above and beyond to get leave to appeal. If there are reasonable prospects of success made out in the application for leave to appeal and in the submissions made by the parties, then that is appropriate for leave to be granted. I'm not entirely sure what the reference to that judgment is, but I found that particular passage of Judge Smith clarifying the standard to be particularly helpful, rather than taking the view that it is only in exceptional circumstances, because it is not what the statute requires, that one has to go above and beyond to obtain leave to appeal.
Thank you, Professor. Allied to that, under what circumstances would it be appropriate to grant leave to appeal to the Supreme Court of Appeal?
That would be if the question is of such importance and complexity that it requires the attention of the Supreme Court of Appeal. Alternatively, it would be where there are conflicting judgments of the High Court.
And lastly, with your leave, Chief Justice, in relation to the exercise of discretion, as an appellate court, where the outcome of the appeal hinges on the exercise of a discretion by the court of first instance, what would be the antecedent question that you would have to decide before you proceed to consider the merits of the appeal?
In relation to the exercise of the discretion?
That is correct.
Whether that was appropriately exercised, given what the circumstances. So in other words, if it is whether the court granted relief that was based on the discretion that it could exercise, whether that indeed was appropriately exercised.
Yes, but would the court not have to determine first and foremost the nature of the discretion which was
Absolutely,
exercised by
absolutely.
the court of first instance?
Absolutely, because in some...
Wide or narrow discretion?
Absolutely. No, absolutely. I think I've misunderstood your question. I apologize.
Thank you, Professor. Thank you, Chief Justice.
We have taken about 35 minutes already. Commissioner Nochesi?
Thank you, Sir. Quick two questions. They relate to the comments by the GCP.
Yes.
Do you not find these comments rather confusing and internally contradicting? Because at paragraph 11.1,
Thank you for pointing that out. When I read through these comments, obviously perhaps strayed, but then was particularly more appreciative of the candidates' judgments are well-researched and impartial, because I think that, for me, is the proof of the pudding.
yeah. And then the second question, which is related to this again, if there is a complaint or somebody says you lack experience because of the time, have you been told how long one must act? He can be appointed or he can apply. Do you know how when, by what time? Should it be 6 months, 2 years, 10 years? Do you know where is that?
I do not know. I would appreciate some clarity, if there is such clarity.
Okay. The last question. Out of all the judgments that I've written, your judgments, these judgments, is there any judgment that has brought or has been pointed out as embarrassingly written or incompetently reflecting or reflecting law badly? Is there any judgment that is something to talk about from these judgments? Is there been such?
Your appointment, do you think we would be living up to that criteria of ensuring that we help reflect the racial and gender composition of South Africa, in particular to that bench of 8 people? Thank you.
My understanding is that these 2 positions relate to the imminent retirement of two of the females who happen to be white, which would then mean that the remaining only female member of the bench in Gqeberha and the remaining members of the bench would be male. So in that sense, I do think that there will be a female composition, but I absolutely admit that what I will bring is another white person to the bench, and I leave that up to the Commission to determine whether that is what that court needs at the moment.
Thank you, Chief Justice. I saw the JP nodding his head when Professor said that there were 2 white females that are going to be vacating the offices. And JP, I would think that is correct. Thank you. Sorry, Chief Justice. JP. I said you were nodding your head when Professor said that there were 2 white females who will be vacating, and these vacancies will have to be filled.
Through you, Chairperson, that
Yes.
is indeed the position.
Okay, all right, thank you. Commissioner Moimang.
Thank you, Chief Justice. Good afternoon, Prof.
Good afternoon.
Just one question from my side, prompted by the article that you wrote, South African Constitutional Court and the Rule of Law, 10 years ago. You seems to have had a problem with how the former Deputy Chief Justice had a problem, had interpreted
who seem to accept that a very brief in passing consultation, in inverted commas, met the requirements of procedural fairness. And the rule of law, most certainly in my understanding, can be either very thin or a very thick concept, and the court has sort of pitched it somewhere in between. And that is my understanding, where it has, for the greater part, always acknowledged that it has a procedural aspect too.
Thank you, Chief Justice. Thank you, Prof.
Thank you. I'm going to go to the commissioners who are attending virtually before I proceed to Commissioner Pillay. Commissioners attending virtually, is there anyone who has a question?
Thank you, Chief Justice. Commissioner
Yes.
Barnard.
Yes, you may go ahead.
Good afternoon, Prof. I'd like to ask you about the, just before I do that, have you sat in any urgent applications?
Yes, I did.
Okay, thanks. As referring to the Yellowstone, Caravan Park, Leppen and versus King, I think, matter, the question I have about that is a practical enforceability of the order, and it goes to the technicality of it. If one looks at paragraph C, so the order in this Yellowstone matter is set out on, I think it's page 64 of the bundle. It seems to be marked with a stamped mark. And paragraph C specifically deals with if the respondent doesn't carry out the order, what then should happen. Now, in practice, normally it's the person who wants the order enforced, which in this case would have been the applicant, that then asks the would instruct the sheriff, and then it would be that party. Would you agree that it would then be that party that would receive the account from the sheriff? Would you agree with that?
If you will just indulge me for a moment, you say page 63. I'm still finding my way here. I do remember, but I can't recall exactly what the agreement between the parties was at the time, or what the... I do seem to have the wrong book here. It's not this one.
If it would assist, I could, to save time, I could just take you through it and then...
I found it, sorry, apologies. Yes.
So it's at the top of page 64.
Yes.
There's paragraph C of your order. So the concern is that ordinarily it would be the applicant in this instance that would be instructing the sheriff and that would be receiving the bill. The problem with this paragraph that we come across in practice from time to time is that where you've ordered here, where courts would order that the respondent should carry the cost. So the order here says, should the respondent fail to remove, then the sheriff may remove and store the chalet and other removed structures at the cost of the respondent. The point is it's going to be the applicant that's giving the sheriff instructions here, but the applicant never has to pay. because the court order says the respondent must pay. Can you see the practical problem that this type of order can hold for the sheriff, for example?
I hear what you're saying, but if I'm not mistaken, that was the request that was requested, the relief that was requested. I stand to be corrected, but that was the requested relief.
I accept
But
that.
I hear what you're saying, absolutely, because in this instance, what would happen is that the applicant, or rather the applicant would give the instruction, but the bill would be made out, or the bill, while it has to be paid by the respondent, it would go to the applicant. That is the issue.
So you see, the practical problem is in practice, we've come across these instances where the respondent then disappears or absconds and never pays,
Yeah.
and the sheriff's bill just mounts and mounts
Yeah.
and mounts, and no one accepts responsibility.
Yeah.
That's the one question. My second question goes to the ad alteram principle, and that is, was the sheriff, I mean, before making this order, which clearly affects the sheriff, was the sheriff asked for representations? I think ordinarily the court wouldn't do that. And I'm wondering if it's such an order which departs from the norm, shouldn't have given the sheriff an opportunity to do so.
Yes, I imagine that it could be, it would be appropriate to ask the sheriff. But as I say, that the terms on the basis on which the order was granted for the greater part was in accordance with the requested relief by the party. But I take your point most certainly that it should be a question of a formulation to ensure that the that the respondent takes responsibility for the costs that are incurred as a result of his non-compliance with the order.
Thank you. My last aspect on this specific thing, once again, it goes as to the law that was applied. Here you have a situation where for years, according to your finding, there was a contravention of the legislation applicable. And yet for years, the applicant had held out to the respondent that that was a valid lease agreement. Now the court now the applicant approaches the court for eviction, and now all of a sudden wants to rely on the contravention of some other legislation. So my question is, isn't this a situation where the applicant should have been stopped from relying on that sort of thing to the detriment of the respondent?
That was not what the applicant relied on. The applicant very particularly did not rely on this. I raised this point miro moto, and I can refer you to paragraph 8 and 9 of the judgment, where I raised this with counsel. That was not the case of the applicant. The case of the applicant was everything but relying on the illegality of the contract. Because if they were to rely on the illegality of the contract, they would have had to admit that in their founding affidavit. And they particularly steered clear of that and relied on all sorts of other fringe issues, but it goes to the root of the agreement between the parties. And yeah, in paragraph 9 of the judgment, I refer to Yanako versus Apollo Club and City Park versus Combined Private Investigation, CC, which is a fairly recent judgment, if I'm not mistaken.
It just seems to me that it's a pretty unfair situation where an applicant now wants an eviction after years and then gets assisted in a sense, but I'll leave that for argument. I don't know if you want to comment on that, and that concludes my questions.
Just very briefly, I dealt with that very pertinently in the judgment. And let me just see now, where did I do that?
Sorry, Chief Justice, I think for argument, but I mean for deliberations.
Yeah, sorry, but yeah, I apologize. But yeah, I comment on that paragraph 30 to 32 of the judgment.
Okay, all right. We are on overtime in regard to these candidate commissioners. So those who have raised their hands, only if you really want to, you insist, I'll allow you, but if you think you can do without the question, it would help. Okay, Commissioner Pillay.
Thank you, Chief Justice. It is quite an important point, and I will try and keep it short.
That's fine.
Good morning, Prof. May I ask you to turn to your Babalwa Madikizela case, if you don't mind?
Yes.
Babalo Madikizela?
If you can get me a page number.
I think it's at paginated page 42.
Okay. It's just one back then. Okay. Thank you.
So this was an urgent application in which the applicant sought to suspend and interdict
Yes.
the remedial action of the public protector. You recall that?
Yes, but they didn't seek to suspend the interdict. They just sought an interdict, interim relief.
Well,
Yes.
your order ultimately suspended the remedial action, and then you interdicted it.
That was the relief that was sought.
Yes, but that's the relief you granted.
Let me just go, I can't from the top of my head.
If you look at
Yep,
page 51,
50 and 51. Let's see. Yeah.
you'll see in prayer C
Yeah.
that the remedial order is suspended. Do you
Yes.
see that? And
Yes.
then in prayer D, that the public protector is interdicted from enforcing a remedial order.
Yes.
Do you see that?
Yes.
Now, if you can just go to the test that you apply, and you'll see that at page 46 of the judgment, where you're going into the test for interim relief. Do you see that?
Yes.
And you refer expressly in paragraph 15 to the decision of Justice Gqeberha in the Gordhan matter. Do you see that?
Yes.
And in that matter, Justice Gqeberha expressly states that the appropriate test to be applied is the outer test,
Yes.
right? And which you properly recognize in that paragraph. My difficulty comes from what happens in the following paragraphs. If you look at the next paragraph where you refer to the outer case, what you do is you extract a portion of the outer judgment that just merely restates the Setlogelo test, right? And you then say that you have to now nuance it in light of the values of the Constitution. What you do is you miss the thrust of the outer case, which is that in order to interdict the performance of a statutory or constitutional function, you need to demonstrate that it's a strong case and it's the clearest of cases. So in other words, you have to make out that it's an exceptional case in order to get such drastic relief. Now that portion of outer, which is really what we as practitioners know and love as the outer test, that portion is not applied in your judgment. And so ultimately you go through the remaining Setlogelo requirements and you come to the conclusion that it's appropriate to grant the relief. And we know that this is relief granted on a default basis.
Yes.
So in other words, there was no respondent in court that could have argued or demonstrated that the test that you were aiming to apply was the incorrect test. And you'll appreciate that a judge sitting in on a default basis has to exercise extra caution.
Absolutely.
All right? And what you see in this judgment is that, firstly, outer is misapplied. And the result is that you do grant quite far-reaching relief on a default basis. So I just want to put that concern to you.
Yeah.
And get a response to that.
I would refer you to paragraph 24 of the judgment. I don't, respectfully, do not think that there was a misunderstanding of the test, because, I mean, obviously, it is the circumstances to the greatest extent mirrors that of EFF versus Gordhan. And in my view, on the basis of what was presented to me by both applicants in that matter, that they have made out the case. I do not think that the outer case uses the terms necessarily exceptional circumstances, because, I mean, I stand corrected. It may or may not. But exceptional circumstances would then take it somewhat further.
Can I say to you, and you know, one of the benefits of being a practitioner
Yes.
is that this is our bread and butter.
Yes.
So we know these tests very well. I can
Yeah.
read to you what outer says. It says, except when a proper and strong case has been made
Yes.
out for the relief, and even so, only in the clearest of cases.
Yes.
So that's the stern language
Yeah.
used in outer. The paragraph that you've referred me to, I've read, and that's a paragraph dealing with balance of convenience.
And it deals
Yes.
with harm, yeah.
Not really what OUTA was about, because OUTA imposed an additional requirement,
yeah.
which is this
Strong, yeah, no,
and
I
clearest
hear
of
you.
cases, and
I
that
hear
was
you.
my concern with your judgment.
Thank you.
Thank you. Let me go back to the commissioners who are attending virtually. Is there any other commissioner attending virtually who has a question that they consider quite important in the light of time?
No questions, thank you.
Not from you. It looks like there's no question from that side. Then it will be Commissioner Kane. I assume your question is important? Yes.
Good afternoon, Ms. Krüger. I represent the GCB, and so I just want to take up the concern, in fairness to you, that they express, which is that you wouldn't have sufficient practical working knowledge of the law in order to yet enjoy the appointment as a judge. Now, earlier you've been questioned by the Chief Justice and other senior judges on your approach to various issues, including discretionary findings, appeals, Plascon Evans, and so on. The run-of-the-mill case that comes before you every day may involve questions like the granting of postponements, exceptions to pleadings, whether a discretion is a wide or a narrow discretion. You may be faced with rules as to whether everything must be in a founding affidavit, how you deal with new issues in reply. Now, tell me what approach you take when those issues arise in court, assuming that this hasn't been your bread and butter for the majority of your professional life. Where are you going to go to get the necessary assistance quickly so that you can efficiently deal with these kind of things in court?
Erasmus, in short. And then following from that, my general approach...
I'm sorry, Professor Kruger.
Yes.
You said something before you said in short, and it may have been part of the answer, but I didn't hear what it was.
Erasmus.
Erasmus, oh,
Yes.
okay.
I would start with Erasmus, but I wouldn't leave it at Erasmus. But that gives you a very clear indication of, because it's quite an extensive commentary on the rules of court, and if it's not in the rules, there's also commentary on the Act. So I would start there, and I've had to deal with exceptions. I've had to deal with a variety of these practical matters, and what I can assure you is that the one thing that I will definitely do is I will research it to the nth, so that for the greater part, and I admit that it's possible that I've made mistakes, and I think everyone will make this mistake, and that's why we have processes in place. I may have made mistakes, but for the greater part, I will go to the ends to try and wrap my head around it, because that's been my bread and butter, to wrap my head around it and make it accessible to other people, students.
Thank you, Chief Justice.
Thank you. There are no further questions. JP?
Thank you for indulging me, CJ. Just one aspect relative to the concern that you acted for 25 weeks. I just want to place it on record that as soon as there were vacancies in Makhanda,
Yes.
I approached you on the basis that you had acted during the first term,
Yes.
2021, and you were going to act during the second term,
Yes.
July to September. I informed you of the vacancies, but you then said to me you would like to get more exposure. Can that go on record?
Yes, that is indeed the truth.
Thank you.
JP, was that before the 25 weeks of acting or after?
It was actually before the expiry of the 25-week period. In other words...
It was during?
Yeah, it was during.
Oh.
In other words, she had acted during the first term, and the positions had been advertised for Makhanda.
Yeah.
And based on the fact that I was constantly supervising her by reason of her background, and my impression of she was developing, I then indicated to her that it was available to her to avail herself for the Makanda vacancies. But she adopted the stance that she thought she would need further exposure, hence she did not avail herself at that particular point in time, and acted further. In other words, from the 4th of October to the 12th of November.
Yes.
I just thought I should place that on record.
Okay, all right.
Thank you.
Thank you. We have come to the end of your interview, Professor Krüger. Do you have 2 or 3 points that you want to emphasize that we must consider? I'm giving you 2 minutes to say if there are any points, or if you are satisfied that all the points have been dealt with that needed to be dealt with, that would be fine too.
No, I would like to thank the Commission for the time, and I would like to thank the JP for the opportunity, because I know it's not the ordinary path, but I believe that people in my position have a contribution to make, as Judges Mokgoro and O'Regan and several other academics have made huge contributions to the jurisprudence in this country. Thank you very much.
Okay, thank you very much. You are now excused.
Thanks so much.
Thank you.